Hello, everyone. Welcome to Tortoise's weekly live open news meeting, coming to you this week, like last week, live from Glasgow. I'm once again stealing one of the radio positions in the press centre here. I'm right next to the Catalonian one this time. The Catalonians have obviously gone off for drinks. And we're very lucky to be joined by two expert guests who I think also have to head off for drinks at some point. So I'm going to limit my remarks, opening remarks, very severely, just to say that when Freddie and Petra, who I will introduce properly in a second, have gone, we might have a few minutes left over in which I really want to hear from everybody, Tortoise colleagues, Tortoise members who are joining us. What do you want to know that you haven't, questions that you need answered, that you haven't had answered yet from COP in the next 2 days? We've got time, got energetic people who can go and ask questions. You get a lot of answers very quickly, as I found out this afternoon in the Blue Zone and in the New York Times Climate Hub, where we are. But we're going to leave that to the end because I want to get to what my colleague Barney was writing about in today's Net Zero Sensemaker special, namely climate litigation. Why? Because we're at the point in COP proceedings when everyone gets a bit depressed and worries whether anything is going to be achieved. I just bumped into a loyal friend and brilliant expert friend of Tortoise, I should say, Isabel Hilton, who has been to many more of these than I have and says this is exactly what happens every time with about two or 3 days to go. People get nervous, people get antsy, and we genuinely don't know if there's going to be a positive outcome or not. Climate litigation, on the other hand, has been showing increasingly that it can actually yield results within the broader effort to shrink national and corporate and individual carbon footprints. So I want to come in just a second to Dr. Petra Minarop, who is in Glasgow for Durham University and is also co-director of the Research Centre for Law and Global Justice, with some general questions about that. But first, because you were quoted by Barney in his newsletter this morning, Dr. Freddie Otto, I'm going to come to you, even though you're not a lawyer, on 2 points, if I may. First, the news. The news out today is that Climate Action Tracker, which measures these things carefully, has said we are on course now for 2.4 degrees of global warming, which contrasts with the 1.5 that we are supposed to be heading towards and the 1.8 that the International Energy Agency said in a rush of blood to the head at the end of last week that we were heading towards. So you are, among other things, a climate modeler. What do these numbers mean? How on earth can they bear any relation to reality? And after that, which one's right?
Yeah, thank you. This is a hard question actually for a climate scientist as well, because what these numbers look at are the NDCs, so the national determined contributions of all the countries taken together, of what the countries have said, have pledged, what they are going to achieve in terms of emission reduction in within the next decades. And there is these pledges are not necessarily as precise as you would like them to be. So right. It is not they say we are going to be net zero by the year 2060 or by the year 2050 or by the year 2070. But some of them, at least on Friday, some countries, and I have forgotten which one it was, I'm sorry, has said they are going to be net zero, and that was a new announcement, by 2060, but they haven't specified whether that means net zero carbon dioxide emissions or net zero all of greenhouse gases. And of course, both are very different and make a huge difference in terms of what we end up we will end up with in terms of temperature targets. And so
Right.
that is one example of the of a very heavy imprecision that some of these NDCs have, but there are also in more slightly less heavy, but still many imprecise things in these NDCs. They don't lay out exactly how many emissions will be reduced by when,
Right.
and so when you make these assumptions of all these trackers that the carbon tracker does and that the IEA does, you have to do some kind of interpretation into what how these NDCs are going to be achieved, what exactly the countries meant, and so that can easily explain differences by a few degrees. And then, of course, it's really important to highlight that they are just pledges. They are not a pathway, a concrete pathway to actually achieve these. And so in terms of whether sort of as estimating what we are heading towards in the future based on these pledges, you also have to do some interpretation of, okay, how realistic is this actually? Or do they have the governance structures to actually do this? Or when will they have the government structures to implement these pledges? And so that's, yeah. So there is, well, the Paris Agreement is fantastic that we have it and that it has clear temperature goals and that it is a bottom-up approach so that countries can do what they can. It also makes for very difficult accounting. And that's one of the reasons why we might need climate litigation, because there is an accounting gap that the Paris Agreement and the NDCs leave open.
And I want to come to that in just a second. But in principle, when India, for example, comes to Glasgow and says we're going to hit net zero by 2070, and they haven't made a pledge of that kind before, you can plug some notional numbers into a model that presumably you have to imagine whether the graph that the line that they take to get to net zero goes like that or like that or like that. But nonetheless, you plug that target in and it affects the overall warming trend in principle. That's what's going on behind the scenes. Is that right?
Yes. So you take that target and say, okay, we will have net zero. And then you have to assume whether it's, I think it was India who was not specifying whether it was carbon dioxide or all greenhouse gases. I'm not sure if they have specified that in the meantime. But yeah, so it will not mean that they will overnight stop burning fossil fuels, but there will be some pathway to get to that. And it might also be that it's a pathway that actually exceeds the carbon budget that we have before reaching net zero, so there's a lot of possible pathways that we can take to get to a certain temperature target and to get to net zero greenhouse gas emissions and net zero carbon dioxide emissions for each country and globally.
Okay, thanks. I hope we can come back to you in a minute to talk about what you were discussing with Barney, namely, among other things, the baffling failure of climate litigants to use the best science available. But first, let's come to Petra. So I don't know if you've had a chance or the privilege to look at Barney's Net Zero Sensemaker on the Tortoise app this morning, but basically, his sources were saying, and I'm sorry, Barney, to be saying this, you should really be saying this, that we are at a point with a growing number of climate litigation cases worldwide, some of them really having success, and a possibility of a real avalanche of cases going forward if one or two key ones that are in the works at the moment, that are being laboriously driven through the courts, are won by the litigants. Is that wishful thinking, or in broad terms, is the mechanism a promising one? And then if you wouldn't mind picking out the cases that you're looking at most carefully.
Yeah, thank you very much. So even though I'm sitting in front of a Durham University screen here, I should add that I am in Glasgow and I'm also speaking in my personal capacity of. So it's a good question. I think strategic climate litigation is on the rise, and it has been on the rise for quite a while. So we've seen really successful cases. I mean, most people here in the audience as well will have heard of the Uganda case. There have been cases that have been then referenced in other courts as well. We see an increase, especially in human rights litigation around the globe, and more cases also emerging in the global south. So this is no longer only a global north phenomenon. In terms of the number of cases, it depends on how you define climate change litigation, because sometimes climate change is an issue that is treated in the periphery, but it could still be a successful case in terms of climate protection. But there are certainly climate litigation cases where climate change is at the heart of the case, and they are probably above 800 cases worldwide. In terms of the structure of these cases, so some cases use human rights as a legal basis for the litigation, and others, and then these human rights cases are mostly against governments reviewing the adequacy of climate targets that have been set, or the ability of the government to reach the carbon emission reduction targets that has been set. And other cases are looking into administrative, procedural law, planning law, so maybe more in that sense an indirect way sometimes to utilize legal provisions to make a claim for adaptation, for compensation. There are some cases that deal with climate impacts directly, where attribution studies are really relevant. One actually in the US that was also won by the claimants. I can say a few words about that. And then there's a relatively famous case, the case against RWE, the German energy provider, that is currently pending in the second instance in the Higher Court of Appeal in Hamm. So tort litigation more widely is also a big branch, a strand of climate litigation that we have seen. And yeah, so the RWE case, if we want to go into more detail into that one, that is not a tort-based claim, that is a nuisance claim.
A nuisance claim?
A nuisance claim, yeah. It's a very traditional claim where you have, where you would like to claim from your neighbor that he's cutting the hanging trees that disturb your property. So it's a property-related claim. Property law is, property right is an absolute right, and you can, if someone disturbs that right, you can claim that this disturber ends the disturbance and removes the disturbance, and if you have to do it yourself, you can then claim the costs. So this is not a damage claim. Yeah, you're not breaching a duty. So the criteria you need to satisfy in court is not that a breach of a duty has occurred. It's not the claim.
Sorry, and this is one of the ones that Barney wrote about this morning, and as I understand it, it is related. It's a claim by a farmer who fears that a dam could break as a result of melting, which is a result of climate change, for which RW is 0.5% responsible. Hence, he's claiming damages to the tune of 0.5% of the cost of rebuilding the dam. Something like that, right?
Yes, absolutely correct.
If this farmer wins, what does that mean for the rest of us?
Well, if that farmer wins that case, then it would be very likely that this provision, which is provision 1004 in the German Civil Code, would be used more widely in similar cases, because that would set a very strong precedent. So claimants here are emphasizing that this is a claim that is used strategically. So it's really to increase the pressure here and to demonstrate that this can be done, that you can hold a big carbon major liable for this kind of disturbance.
But, I mean, just to be clear, that the effect that the farmer in this case is complaining about is by definition global. So if he wins, then every farmer in Nepal, in Kyrgyzstan, in the Alps, who feels at risk from glacial meltwater or abnormal snowmelt can bring a case against RWE, or for that matter, any. Does it have to be a German energy company because the jurisdiction is the German court?
Well, yeah, you would need to find the territorial jurisdiction so that the German civil code is applicable. And this is here the case because the headquarters of the RWE are in Germany. It really depends here on the scientific evidence. If you can prove in court, and we haven't really established yet that this has been done, but if you can absolutely prove in court and convince the judge to realize that there is a significant contribution, so it's not just any contribution that any of us perhaps has also made to this increase in the probability or in the occurrence of this flooding. If you convince the court, then it would still mean that in a parallel situation, let's assume it's a case against Heidelberg Cement, we would still need to gain evidence that this is that there is an increase in the likelihood of a risk and it's above a certain threshold, and you can bring this entire causal chain in place.
As you've explained, there are other bases, obviously, on which to bring climate-related cases, human rights-based ones, and there was a very complicated one that was the basis of the case against Exxon in the Southern District of New York last year, which was about the impact of withholding market-sensitive financial information. They lost, but give us the big picture here. Are we moving, in your view, towards a moment when the big emitters globally say things have changed, we are in for an absolute punishing from class action suits all over the world. Let's try and sit down with the litigants, which is, let's face it, the population of the world, and make a massive contribution to the kind of climate finance, which, to bring it back to Glasgow, is what everyone's talking about. And could the law in that way become a mechanism, a nudging mechanism, as it were, to within the larger process that is unfolding in COP?
Yes, absolutely. I think climate litigation is even more than just a nudging mechanism. It really supports what's going on in the UNFCCC negotiations. That's absolutely the case. In terms of what we see in changes, I mean, this kind of wave has been building up over a long time. And maybe what is changing now is that there are more companies signing up and making certain pledges. So for example, the coal pledge has been also undersigned by some corporate actors. So if we have a corporate actor that has signed up to net zero by 2050, as for example, Shell, then of course you can hold these companies to account, and that again demands that they know and that they can implement accounting procedures as well. So they will need to do something that until now mostly states had to do. They had to apply the IPCC guidelines and provide the accounting. And this is now something that companies will also have to do. And where probably one of the big future liability risk is, or litigation risk, if you want, is in this supply chain and value chain litigation, where we will see that companies need to know where their scope 1, 2, and 3 emissions are coming from. Banks will need to know that when they lend money somewhere, so that they're not supporting coal if they have signed up to ending that. So I think there's probably a new mechanism emerging and a new risk emerging, and there are also some new laws. And in Germany, there's a new supply chain legislation that will come into force that will probably give rise to further climate change litigation. But I think another really effective route in terms of using the law here is the human rights approach, or the fundamental rights approach, and making this argument that a state that doesn't have a climate reduction target that is ambitious, and a state has signed up to the Paris Agreement and said, I will make the most ambitious pledge, not compared to other states, but to what I can do as an economy, then I think there can be a reasonable argument made that fundamental rights can be endangered, given that we know so much about the science.
Right. Thank you. If you're still around, I want to come back to you in a minute on a particular point. But first, let's come back to Freddie. You did some work on 80 cases in which you found, or sorry, you'll have to explain to me, in which the courts found that the science was deficient. Tell us a bit more about that.
Yeah, so it wasn't me. It was led by my PhD student Rupert, and actually Petra was also involved in this paper. It was an effort that a bunch of lawyers and me as a scientist and my PhD student did, and we looked at about 80 past and ongoing cases that have made some use of science and in particular of the science that Petra was talking about earlier, about the science of attribution. So causally linking emissions from individual emitters, countries globally, to global mean temperature, to concrete damages, and closing this causal chain. So we looked at cases where, from how the cases are set up, this kind of science could have been relevant, or might have been relevant, or where these kind of causal claims are in some way made. So it's tort law, for example. It's not mainly the human rights type of cases, but more the litigation cases, and have looked at in all stages of the cases. So in the very first, just really asking the courts to look at them, to actually going to judgment, looked at what the role of science was, and particularly what the scientific evidence was that has been brought and how it has been interpreted by the courts. And we found that there was that there is a huge discrepancy between what you can say from a scientific point of view, so what the state of the art in science is, and what has been brought in front of the courts. So in some cases, that is that, for example, those who have actually brought the cases, NGOs or individuals or groups of people, for example, not provided any evidence that actually greenhouse gas emissions from burning fossil fuels are responsible for the damages. They just, that was just implied.
Taken as read.
Or it's been for cases where actually, and these are cases where you could bring it, but it hasn't been brought. Or there are examples where types of extremes where it would be extremely difficult to provide any causal evidence have been brought, because we don't have actually that kind of data that you would need. So it just showed that there is a big discrepancy between what we can say in the science and what's in the IPCC reports, and actually what the courts deal with.
There's baffling from a process point of view, because it's really expensive and stressful to bring a case in court. You'd have thought that the first thing you would do is refer to the best science available. The IPCC reports have always been publicly available. So is there an example of an NGO that just relied on stuff that was inadequate and they should have known better from the get-go?
Well, I think it's difficult to say that they should have known better from the get-go, because while the most recent IPCC report is assessing this literature about individual extreme events and how they are changing at length, but that is in the previous IPCC report, there was basically half a page somewhere buried in the report saying this is not something that you could do, but it hadn't been done in a large scale. So I don't think there is anyone to blame. It just shows that the speed in which the science evolves, and the communication and the understanding of the public, and ultimately these NGOs and of course judges are members of the public who mainly get their scientific education from the media, from the news. or from, and so that this translation isn't really fast enough and to actually serve these kind of cases well. And I think the conclusion that we need to draw is that to ensure greater success for these cases, lawyers and scientists need to work closer together, and maybe we need to write not only a summary for policymakers from the IPCC, but a summary for judges, or so that there is a bit faster translation of what we can say and what we can't say from a scientific point of view.
Yeah, that would be such a great idea, because judges are not barred, obviously, from reading the Daily Telegraph, which is a good paper in some respects, but antediluvian in others. I'm not sure if I'm allowed to say that, but I did. Petra, before you go to your dinner, I just want to come back to the sort of accountability that corporate actors are subject to when they sign up to a net zero target. These are not necessarily binding in law, are they? Or are they?
Well, that depends. But, sometimes even some of these pledges are, all of these, the Forest Pledge, the Financial for Forest Pledge, the End to Coal Power or Power Past Coal Alliance, all of these are pledges that are not legally binding in that sense. But that doesn't necessarily mean that they will not be adhered to. You just can't enforce them. So I think what we must realize is that for the enforcement mechanisms, we still rely on the domestic legal frameworks and on the rule of law. Even if you've got a really nice judgment, you still need to have the administration, the procedure that follows to implement it. And we've seen that in some of these cases that have been hailed as a great success, and they haven't really been implemented afterwards. If I can just say, so some judges are looking into the science. So we've seen that in the constitutional court's decision in Germany, actually, that has at length looked into the IPCC report and the carbon budget.
Petra, before you go, let me ask one more question. Is it the case that the courts and climate litigants played a part, possibly a big one, in one undoubted UK climate success, namely removing coal from the power generation system? I may be misremembering this, but as I understood it, there was a government undertaking which was then broken, and it was because the UK government was forced by the courts or by a litigation to keep its own promise that we had this rapid. No, have I got this wrong?
I'm not entirely sure which case you're referring to. I'm not sure. We have discussed the case in Heathrow third one-way, but that was the case that the Supreme Court unfortunately overturned, where the Court of Appeal had held that the third one-way can't be built, but then the final instance overturned the decision and decided otherwise. So I'm not entirely sure.
Oh, I see. So I thought that there had been a piece of litigation that forced the UK government to keep its promise to remove coal from the power sector, and as a result, we've had this dramatic reduction of 60 to 4% of UK power is provided by the coal sector. As I understood it, there was a bit of litigation in there, but I may be wrong.
Yeah. So yeah. No, you go on.
Tell us about the Heathrow one briefly, then you can go to your supper.
Well, yes. So the Heathrow one, that was the decision where it was questioned whether the Secretary of State had to take the Paris Agreement as a climate change consideration into account when approving or making the decision concerning the third one-way. And that was actually application of the UK 2008 Planning Act, where the provision states that climate change considerations are public policy and they need to be taken into account. So the Court of Appeal held that by not taking the Paris Agreement into account, the Secretary had stayed and not discharged the duty of taking climate change considerations into account. But the Supreme Court found that the provision had to be interpreted in a way that public policy excluded the Paris Agreement because of the dualist system of the UK, where you need to have an implementing act of parliament if you sign up to an international treaty, which is true, which is in many dualist jurisdictions the case. But in this particular case, the question was only whether the Paris Agreement was part of public policy. It wasn't the question of whether it was legally enforceable. And in that sense, ratifying an international treaty should turn it into a piece of public policy. I think that argument could be made at least, and this is how the Court of Appeal interpreted it. But yeah, there was a different view. You can argue, of course, and say that government policy or public policy demands that you have a particular piece of policy that is labeled as such.
But as it happened, the Court of Appeal's ruling was timely in that it took the juice out of the whole proposal, which has not been revived, partly, I guess, because of COVID. That's the case, isn't it? That nobody's building a third runway now.
Yeah, I think it's the government's final decision now what they want to do, isn't it? So it's I don't think this matter is closed.
Oh, right, it'll go on, and we'll drag in the former MP for Uxbridge and his friend Lord Goldsmith, who's, yeah, goodness knows. Right, listen, thank you very much, and please don't feel you have to stay on, but we've been very lucky to have your input this first half hour. And one of the things we're going to do in the next half hour is figure out which of these law cases is the most compelling story for us to tell in depth, and then we'll send Barney back to interview about it in depth. But thank you very much for joining us. Now, Freddie, you're still with us, so I want to pick you up on one thing in case we have to let you go too. You are quoted by Barney as saying that better coordination between lawyers and scientists would represent a huge opportunity. In all the different, I know you're not a lawyer, but can you just expand on that a bit? Where do you think science harnessed by law could have most impact, over the next few years, and in terms of the categories of cases that we've been discussing, whether human rights ones or nuisance ones or tort ones? And I use that word without really understanding at all what it means.
Well, yeah, that's how I deal with law all the time, right? I talk about it without really understanding what it means. But so there are the Paris Agreement is I think it's probably easiest to start with that. Has targets and has goals, but it has also there are a lot of gaps in the Paris Agreement. It doesn't prescribe every country and every industry a specific pathway of how to go about limiting their emissions and how and what to do in terms of adaptation and loss and damage. So there are gaps, and I've said at the beginning, there are gaps in terms of accountability, because it doesn't exactly say how do you count what, and Petra has talked about that there will be a huge bunch of cases probably on that, because at the moment basically every large company has their own set of sustainability risk assessments, which is basically a black box, and no one really knows exactly what goes in and what goes out, and so that the law will probably play an important role in making that clearer, more transparent, and more coherent globally. And then there is a gap in terms of ambitions. And I think we have seen a very, very interesting and impressive case on that in Germany, where Luisa Neubauer and others from the Fridays for Futures have sued the German government for their rather unambitious climate law, because it was not compatible with the Paris Agreement, particularly not compatible with the part of the Paris Agreement that says the rich and historically responsible countries are going are going in front with their ambitions. So that case was successful and has forced the German government to make a better law. So I think that was a very important case for how the law can actually help enforce the Paris Agreement and close one of these ambition gaps. And we've seen similar stuff then in Belgium and in the Netherlands. But there's another big gap, and that's, I would say, the equity gap, because while NDCs are relatively vague and lacking metrics, there at least are metrics for mitigation, for emission reduction, and so on. But there are no metrics. There is on adaptation. There is no inventory on what the impacts of climate change today are. Loss and damage is not. It's not even defined what loss and damage means. So, but climate change is happening here and now, and costing lives and livelihoods of the most vulnerable in globally, but also in every society. And that is currently still largely ignored at the COP and also in other fora. But it is something that we need to address, because otherwise the Paris Agreement cannot be implemented if it's not done in a more just and equitable way. And I think that is where the litigation cases, when we're taught law, can play an important role, and where probably the scientific development that we had over the last decade in actually closing this causal chain can really, really make a difference. And I don't think it's a question of whether there will be a successful case for someone being successfully sued for damages, but I think it's just a question of where and when. Because I think that is something that I don't see being properly addressed at the COP ever, because defining loss and damage is pretty impossible in an international forum, but in front of a national court, it might not be. And therefore, I think this is really important, or one important lever towards more climate justice are the courts, and where the science could help.
Let's be clear that there have been some successful cases. You're just saying there hasn't yet been a successful one, a loss and damage case.
Yes.
Right. Can we just go back to the Lisa Neubauer case? Because there's the question of equity between rich and poor countries on which the Constitutional Court ruled, but also between younger and older generations, right? Wasn't that an issue in that case?
So in the German case, that was an important aspect of the ruling, that because of the way it was not only that the German climate law was not ambitious enough, it was also that they put too much burden on future generations, in terms of, because they basically said, well, we'll reduce some emissions in the next few years, but then after 10, 20 years time, there will be massive emission reductions, which of course is then on future generation, future governments. And the court ruling was that this is not okay. You can't do that.
And briefly, I know that we could spend a day on German constitutional law, but
not
can anyone
me,
appeal a German constitutional? No, but can anyone appeal a constitutional court ruling, or is that it?
It's it. That's it. That's the highest court in Germany.
So aren't the implications of this case colossal already?
Yes. It has been referred to as a landmark case, and it really was, because it showed on the one hand that, which I think is really important, that in Germany the Paris Agreement is legally binding. So you can't not, if you don't adhere to it, you break the law. And I think that is just incredibly powerful. I don't think it has really sunk in, but it is huge.
I need to go to William in the chat in a second, but before we say goodbye to you, Freddie, what was it like testifying against Bolsonaro?
Well, I haven't really testified yet.
I know,
at least.
but we're journalists.
It's we provided the scientific evidence on which basis which is the basis for the complaint in the ICU. So it's to be honest, it's
the
not
ICU. So it's not in Brazil.
No. It's the International Criminal Court.
Okay.
For crimes against humanity. So it's a human rights case complaint, and you would need to speak to a lawyer what exactly the difference between a complaint for that and other types of things you can do in front of that court is. But the case is, the argument is that the huge increase in deforestation and the emissions that have got into the atmosphere because of that, in addition, they have caused caused people to die because of increase in heat waves and so on, and that is why it's a crime against humanity, and so it can go to this criminal court. So that and what I did was to work out this scientific causal chain of, okay, this is what Bolsonaro's government has done in terms of deforestation, which has led to these emissions. These emissions have caused these heat waves to become more intense, more likely, which increases the mortality. And so you can say that Bolsonaro is responsible for the death of these people, which is the argument. And so, I can't say what it's like, but I think it's important that actually I think it's very unlikely that this will be successful, but I think to actually put all these pieces together and put this evidence together and talk about these decisions to not stop emissions and to increase emissions, what that actually means, I think that is really important and powerful.
The court which is in The Hague, has said it will hear it. That's where we've got to.
No. That it hasn't made any decision yet.
Okay.
It has just received the paperwork, and we'll see what happens.
Okay. Well,
that would if it would hear it, that would already be huge. So that would already be a huge success. But yeah.
Yeah. Well, we'll see. Maybe there's a sort of self-reinforcing momentum. William, thank you very much, Freddie. And if you have to go,
yes, I will.
You for helping us out. Thank you so much for joining us. And don't be surprised if we follow up with more questions. You get the emails.
Oh, yeah.
William, you have answered my call.
Giles.
Two questions for the rest of COP. What do you want to know?
Well, what I want to know is there enough what you could call empathetic, imaginative leadership going on to encourage the idea that we are going to have to change the world as we know it to be, or that insofar as is being talked about, and we are reaching for solutions that feel comfortable to us, like litigation, financing, involvement of corporations, etc., which is, of course, what we as humans tend to do because we want the future to be a better version of what today is. But I'm just wondering whether that's not completely for the birds if what we are looking at in 30, 40, 50 years' time is actually a dystopian future that's more like Dune and The Handmaid's Tale. Now, that's a sort of very big, broad question, but I'm just wondering whether there's a role
William,
for it.
Yeah, no, I'm going to invite, in a minute, I'm going to invite my colleagues who are up here with me, Barney, Ellen, looking at you, to give a view on whether, I mean, we can look into this in more detail on whether you think there has been any evidence of that sort of leadership. But William, what's your second question first?
What's my second question?
You said there were two questions in the chat.
Yes, there's the question of leadership.
Right.
But there's also a question of encouragement of us all on an everyday, more mundane level to do with buying in and participation as to how this enormous change has to take place, how we all can show the leadership in our own everyday lives.
Right.
Necessarily as well. And to what extent are the solutions actually in our grasp, like Martha Lane Fox was saying? We just need to go faster, or are we kidding ourselves on a very, very deep level? Now, I know these things are complicated, but are we not addressing these complications because they're too complicated? Does any of that make sense?
Yes.
It's interlocking and interweaving, and it's not easy.
True. I think it does make sense. Ellen, have you seen, wandering around Glasgow, any evidence of the kind of leadership to, quote, encourage the idea that we are going to have to change the world? I don't think anyone could put quite the same emphasis on it as William, but you heard. You see any of that?
Well, I think so. The spaces that I've been in Glasgow have been more of the sort of civil society spaces, and that's maybe not the conventional sort of. Can you hear me?
Yeah.
Yeah, the conventional sort of leadership that William is talking about, but it is a form of leadership. You know, we sort of said that in the Net Zero Sensemaker that Phoebe wrote at the beginning of the week about Greta, but of course it's not just Greta. It's, you know, it's all of the young climate activists and also the indigenous groups that are really pushing and aren't going to stop pushing the more conventional leadership to act. So I do think that's for me where the kind of hope is, and I feel like it has had a slow burn effect to get us to where we are. And even if, you know, well, we'll see tomorrow morning, I think, what the kind of cover statement is from COP26. But even if that's not dramatically better, if it's just little steps forward, I think that leadership from those groups will have played a part.
Is it really, I see your hand up, Kerry, and thank you. We'll come to that in a second. Is it really cynical of me, though, Ellen, to think that for leadership to be real, it's got to be connected to power, and it doesn't feel here, given the system that we've all sort of embraced, that the leadership offered by Greta and others in the streets is connected to power?
I think it's connected to influence, which is not the same as power, but it's it filters through. Yeah. And I think it's undeniable that it has filtered through. Not perhaps, you know, not strongly enough. There's more to do, but there's a connection. It's just more diffuse.
I think that's probably very true. Kerry, what did you want to say?
Look, I wanted to say I found this whole thing really fascinating, and so I started off thinking this whole point about litigation is really interesting because I haven't thought about it at all. I've thought about finance and insurance and the effect that those things will have on companies who want to build a coal plant or whatever the thing might be, but I hadn't thought about litigation. And then actually, as the conversation went on, and when you sort of probed away at the problem of causality and showing causality, I was trying to think, well, what's the analogy that works? What, you know, like you, I'm about as much of a legal expert as you are, Giles, so we're, you know, in the same boat here. What's if I'm trying to get my head around how this litigation would work, then what's my analogy? And I guess that I'd be interested to hear what other people think on this. The closest I got was the pandemic. And I thought, well, maybe then that feels easier because as a citizen of, you can see legal action in France, for example, against failures of the government there on the pandemic. We may come to that in the UK as well. But the causality is easier to show, I think, than it is in the case of climate change. So having found it fascinating, first of all, fascinating because I really hadn't thought about it, I've kind of ended up wondering if I haven't thought about it, because actually it seems to me that it's pretty unlikely to be a very viable route to go down. I'm not sure how the human rights thing works when the causality is so fuzzy. And
yes, but Kerry, two things occurred to me, and then we'll come to Liz is going on about nuclear and tobacco. Tobacco was what I was going to say. Like in the 50s, it was inconceivable that a massive class action lawsuit would bring the tobacco industry within the US at least to its knees.
But causality is easy in tobacco, isn't it?
Yes, and I agree that it's very fuzzy in some climate cases, but isn't it the case in, I think there was one, by the way, with the UK government and with Shell, that if you can get public bodies and companies to make promises that they then break.
Yeah, and actually that's right, Giles. That does feel more likely that, as Freddie was saying, or Petra, I think, was saying that if a treaty like Paris has the force of domestic law, then you've got a standard you can hold a government to. And I can equally imagine that as sustainable green goals become front and center for companies and move their share price, then there's a thing that as a shareholder, you can hold a company to. If it's made a promise of cutting emissions by X or Y, then I guess you can see how there's a standard there that you could potentially pursue through the courts if they've come up short. So yeah, maybe on those.
I mean, look, from a storytelling point of view, I think there's plenty of ammo for the next Erin Brockovich, and we certainly want to make that into a podcast, don't we? It's just a case of choosing the right case. And I'm going to come to Barney in a second and ask him what his favorite one, what if he was given a week or a month to pursue it in detail, which would it be? But Liz, do you want us to go big on nuclear?
I just wondered, forgive me, I was away last week, so I missed the first half of COP, and I'm joining for the second half, which is also how I do football matches. I just don't know. So never read LinkedIn. I mean, that's also good advice. But there's a lot of chat over with the good people of LinkedIn smugly saying, oh, if you're looking for a smart takeaway from COP, then nuclear is the answer. But nobody seems to be talking about that. And I just want to know, well, is it the answer? And also, are they really not talking about it? I haven't sort of come across it. And Phoebe talks about nuclear as a not clean option. So I don't really know how I'm supposed to feel about nuclear. I don't really know.
Okay. Well, I can report that they have the nuclear industry, the UK nuclear industry, I think it is, or maybe an international association, has a fairly sizable pavilion in Zone D, which is about half a mile and under covered walkways from where I am now. But it's a lonely corner of Zone D. All the action is around the Brazilian pavilions, and it's not just because of the samba and that kind of stuff. It's because it's really important. The Brazilian, the UK, the EU, the Swedish. I walked past the nuclear one and nothing doing. Very small part of the chat. I didn't see what Phoebe said. But I think in a very important respect, it is clean, right? Ain't no CO2 from there, and it's reliable baseload. Dan, I see that in the chat. Yes, please. Let's talk. Let's share those documents. But just on nuclear, Why is it not? I don't speak as an expert here, but one reason why it's not a bigger part of the conversation is because it's so expensive and renewables are so cheap that they have muscled their way right into the middle of the conversation, which is where nuclear would be if it wasn't for the fact that wind and solar were now cheaper than coal, for example. And so now the big technical question is, how can you level out the supply curve when it stops blowing wind and the sun goes down? Barney.
Hello.
Barney. So which of the I shouldn't cave to my temptation to write this, but which of the cases that you wrote about this morning is the Erin Brockovich story?
Can I choose a completely different one?
Yep.
Yeah. Okay. So there's a
Bear in mind, you probably will be commissioned to investigate more deeply.
Good. Let's do it. There's a really interesting case actually I did come across during this, which I think is a sort of expanding area in climate litigation as well, which is kind of focusing on supply chains and kind of looking at how, whether a company's deforestation practices can be kind of held to account in the home country where they're based and headquartered. And there's a really interesting case being brought by sort of 11 Amazonian tribes who've kind of coupled together and sort of brought this case against Casino, which is this French supermarket, basically arguing that the practices that Casino had throughout its value chain have basically led to deforestation of their home. A meat company has come in there onto their land and basically taken several, taken down the trees and essentially committed the land to farming practices. And obviously, as we're talking about before, there's a lot of points that we've got to get through here to kind of make sense of the fact of this causes this and that, moves on to that. Mm-hmm. I think it's a really complicated and kind of nitty bit of sort of legal wrangling that has to happen. But if it comes off, it's huge. It's basically saying that someone from somewhere far across on the other side of the world has had their home destroyed, and this company has something to do with it. I think it's got a massive sort of implication if things like that go through.
Last question before I run out of time. How do these cases work? Because don't tell me the leaders of the 11 tribes picked up the phone and said, I know a great lawyer in Paris. Let's sue Casino. This is a French NGO, is it? Or
no, absolutely, yeah. So this would be an NGO that kind of works closely with these tribes already, but has realised that there's a potential here and has found a discrepancy in the value chain and has decided that this is something that should be brought forward, and has recommended to these tribes that they group together in a legal case and basically bring it in France. There's one other.
And it's more than the NGO seeking a legal way to generate publicity.
I mean, I suppose that's open to interpretation, but I'd say no. I reckon they have their heart in the right place on there. But
yeah, no. But from a journalistic point of view, I think the story would fizzle if it turned out to be. We need the courtroom scene at the end, right?
Absolutely, yeah, of course.
Yeah. Go on. There was one more. Then we'll have to wrap up.
It's the case of the climate grannies, which I quite like, which is this group of they're called the Union of Swiss Senior Women for Climate Protection, and they're all above 75, and they've basically argued in the European Court of Human Rights that their right to life has been violated, and it's really interesting because it was kind of put down a couple of years ago, and now it's been picked up again. And during this session at the New York Times Climate Hub yesterday, was sort of mentioning this could be really interesting as well. It shows that there's a sort of intergenerational kind of element to this that is working as well.
Excellent. I can't top that. The Union of Senior Swiss Women for Climate Protection. Okay. Well, full disclosure, climate litigation is something that we have actually been looking at the right avenue into it for a long time, but I think we've taken a step forward at COP. Thanks mainly to Barney and our guests. Thanks everyone else for joining us. Thanks fellow tortoises. Looking forward to seeing you back in London soon. What we haven't talked about at all is whether it's going to be a deal here. They'll say there is one. I think it might be a pretty thin deal. Good night and see you again soon. Thanks everyone.